I guess we have had opportunity to look at the paper we have. It's now time for us to break out into sessions, into classes, and since the class has a natural divide, we'll just take it this side and then this side. So I don't know whether we can move our chair a little bit to this side, and then we'll move the chair a little bit to this side so that we can have the group talk about the paper we have, so that we can do our role playing. Because if you are where you are, you'll be disturbing, each class will be disturbing the other. But if you move your chair a little bit to the side and you move your chair a little bit to this side, it makes it easier for you to discuss. This is the practical aspect, because it's not about teaching, it's about us doing it. Please, can we assist and the instructor is actually going to come to the two classes. One, Demi will be here and Scott will be here, so that he will go over it with you, and then we'll pick our roles, the people that will do the direct examination based on the case we have. Yes, if you move your chair a little bit, because they have tables there already. They already have tables, so maybe if you just move your chair so that you can discuss with them. Exactly. Because they already have tables there, so it's just to move your chair a little bit so that you can talk. Because you're not going to use microphone.
Okay, so you have taken it out now.
No, it will not affect. It will not affect. No.
He says that he's hit in the head with a wrench, or he hit him in the head with a wrench. So Jones admits that. Yeah, I mean it's a toss-up. I mean this is a. If I'm a judge, I'm going to have a hard time knowing which way I'm going to rule on this. I mean, this is a toss-up. I mean, it could go either way.
Come to think of it, this Smith of a man was said to be drunk, and this is to the knowledge of Jones, which means he's not properly thinking. And the rooms 101, 110, 110. Wouldn't Smith? Shouldn't Smith have been thinking he was going into his room?
He was drunk, you know. He's brothers with. They're in the same company. You're around. It's like a family. You're in a company with these people. It's like you're literally with them day and night. I mean, you're going to the mess hall with them. You're going and doing drills with them. You're doing exercises with them. You're around these people constantly. This is like your brother, you know. I mean. Yeah, my siblings annoy me at times, but I should be able to go into my siblings' room and say, hey, I want to watch TV. I mean, this is the type of relationship that we're dealing with. So I think, you know, it can be argued, Smith is just like, hey, I didn't think I was offending this guy. I just want to go watch some TV with him. Yeah, maybe I was drunk, but it doesn't allow him to hit me in the head with the wrench. All right, using... So I'm going to be the victim, Smith. Anyone want to ask me questions? So what we'll do is we'll have someone, and I think we'll use the microphone for this. So if someone wants to come, and I'm going to swear that I'm going to Smith. To the best of my recollection and knowledge, based off the any volunteers? You want to? And we're going to do direct, and then we'll do a kind of a practice cross-examination, and then we'll do kind of a demonstrative. So we'll do a direct, then we'll have someone else do a demonstrative. Cross-examination, and then we'll do a redirect. So we'll start with the direct questions. So let's get you a chair.
Examination.
Direct.
Examination.
Yes, direct examination. You can stand. I'm going to sit down. And so this is, you are the judge. So you guys, you're the judge here. And so you're deciding the facts here. And this is our prosecutor, and
You have to stand at the first. No, the lawyer.
oh, it's not working?
How do I try?
Hello? Oh, it's going through the live stream. Okay. Oh, so I'll just let it sit. Let's not, like... Alright, so talk loud when you ask your questions so everyone can hear.
Oh, what you said your question was?
So I'm Smith.
Smith.
You're just...
The victim.
The victim. You are the victim.
Yes.
Now, I need to consult you privately before we commence.
Alright, we'll take 2 minutes real quick so you can talk with me real quick.
Just dim it with Azunga.
Now, if we use the answer, no, if we use the question where, why, how,
Okay.
when, and time, alright?
Yes.
These are going to be my areas of defense.
Yes. You're the prosecutor, so you're trying to establish that Mr. Jones should be held criminally liable for this.
Okay. For all these, huh?
Yeah.
And where's Mr. Jones now?
Mr. Jones is.
We want somebody.
We'll deal with that later. So for right now, we're just focusing on Smith. So. All right. So you want to call? We're going to be formal here. Go ahead and call your next witness. Which would be me.
No,
which will be me.
Okay.
Yeah.
You tell the audience your full names.
No, you invite him.
Yes.
Seek permission.
I'd like to call my next witness, Mr. Smith.
Okay.
Yes.
Now, my next witness is Mr. Smith.
Okay. And I swear to tell the truth according to my recollection of the facts according to this paper of Mr. Smith's.
Now, do you know?
I don't know him.
Do you know the victim?
I am the victim.
Now, do you know the assailants?
Yes, I do.
Now, can you narrate in brief?
Without introducing matter.
So,
where does he live? His occupation?
yeah. So ask me some introductory questions. Yeah. So exactly.
You know the parties.
Yeah. So ask
You
me.
know the parties.
Maybe ask me like a simple question. Like, just start off. What's my name?
Okay, what's your name?
My name is Private Smith.
What do you do for a living?
I'm in the United States Army.
Where do you live?
I live at the Army base in Arizona, at the barracks at that base.
You know why you are here?
I was summoned to come testify.
You know what you are going to testify upon?
At this point, no.
You should be able to know the exact scenario that happened.
But you need to you're going to have to elicit those questions from me.
Okay, proceed.
Yeah. Okay.
Now, what do you know that transpired between the assailant and yourself?
On a date back in, it was a Friday in February. I can't really remember too much, but I went over to this guy Jones. He's in my company with me. He's another private. I went over to his barracks, into his room, and next thing I know, I'm getting hit in the head.
You give me a hit in the head?
The guy hit in the head.
Why?
I don't know. I just
Why?
went over to his room, and he just hit me in the head.
What happened before he hit on the head?
I went over there. I'd been drinking a little bit, and I just went into his room. And next thing I know, he's telling me to get out, and then he hits me in the head with the wrench.
What was your relationship before you went to his house?
Could you repeat that?
What was the relationship between you and him before you went to his house?
You know, we're in the same company together, so we know each other really well. We go to dinner all the time. I mean, as a company, we eat together. We sleep in the same barracks together, and we're like a band of brothers.
Before this date, have you had any coercion marriage in the point of view?
No, I always liked the guy. He's one of the guys in my company. I mean, he's cool. I think he's, I would go watch TV in his room if I didn't think the guy's a cool guy.
Well, I'm saying before this date, the relationship was very cordial between you.
Yeah, we're friends. I say we're friends.
Now, before hitting you on the head, Can you remember the nature of the object?
All I know was something sharp. It hit me in the head. I could feel I was bleeding. I don't know exactly what it was. It was something sharp.
Now, after the hit, were you normal? Or you became unconscious?
All I know is he hit me in the head, and then I tried to walk out of the room, and he hit me a second time in the head. And next thing I know, I woke up. I was at the hospital.
Which of the hospital? Can you remember?
University Hospital.
Now, what was that? And how many days did you spend in the hospital?
I spent the night there. They wanted to make sure, they kind of give me a concussion protocol. They wanted to make sure I didn't have a concussion. I had to get some stitches where the sharp object hit me in the head. They had to stitch me up. So.
Thereafter, were you given a report by the doctor?
Yeah, I got a medical report. I saw that they stitched me up and they ruled out a concussion after that first night there.
Now, can you be able to recognize the report if you see it?
Yes.
Do you know the name of the doctor that treated you?
It was Dr. Baker.
Now, the report given to you, how can you identify it for the court? If you see it.
If you show it to me, I'd be able to tell you that.
How can you identify it?
I would know because it probably have my name on it and something on there that shows us that report.
Have a look at this machine.
I don't know. I've never seen this report before. This must be a fraudulent doc. I'm just joking.
Is that the report?
That's the report.
Very well. With your kind permission, may I seek to tender this?
No, admitted.
Admitted.
So that is this is for this witness. We are done with this witness.
Okay. Let's hold on. Let's go back and let's critique this a little bit. So let's ask this question: were all the elements established? So what's our elements? Okay, I see a hand back there. So tell me, what are we? Tell me what we're missing or not missing.
Well, on that particular day, it was in the evening. I had gone to the mess to hang out after I had this training, and I had taken a few alcoholic drinks. I was in the bar for some time. I left the bar eventually, and I thought to pay a visit on the way to back to my room. My room is 110, and Private Jones' room is 101. So on my way back to my room, I decided to stop by and say hello to him, since we hadn't seen him at the mess. Now I got to his room, I knocked and I went in, and he was in the room obviously. I hung out in the room for a few minutes. No, I knocked and I went in. He was sitting on the bench.
Next attorney. Next up. Okay, walk in the room and sitting on the bed.
Yes. Yes. No, I did not. No, I was.
Objection, wait.
I was leading.
I was leading. Nice.
Yes.
When he entered.
When I entered the room, like I said earlier, he was sitting on the bed. The television was on. So I sat down and I joined him in watching the television. At a point, while I was still in the room, he became agitated for whatever reason I do not know. And he asked me to leave his room. And being the peaceful person that I am, I got up and decided to walk out of his room. And on my way out, I felt him rushing towards me, and the next thing, I felt a blow on the back of my head. And I went down on the floor. And as I was trying to rise and get my feet under me, I felt another blow to the front of my head. And that was the last thing I remembered until I woke up in the hospital with stitches in my head.
So from that point, I would clarify who all was in the room. Was there only one person? Were there many people? So let's back up a little bit and go back to when you entered the room.
Yes. I cannot recall. The last thing I remember was the blow to the front of my head. No, there wasn't any other person.
Was there any possibility of them having gone out before the attack?
No, it's not possible.
Objection, Your Worship. That question is leading. Question is leading.
So use this as an example. Okay, let's you talked about you woke up in the hospital. Let's go back to when you were in the room with the accused.
Yes, like
at the time.
Are you
Yes.
arguing with your own witness? Simple question.
Like I said
Break it down.
earlier,
'Cause that was about 2.5 questions in there.
like I said earlier, I went into the room. Private Jones was sitting on the bed. He was all alone in the room. And I sat down with him for a few moments watching the television.
Okay,
When
next
he
attorney.
became agitated and asked me to
Nice job.
leave the room.
Who's the next attorney up? Oh, you're being so polite. You're doing a nice job. Wherever you'd like.
Yes.
We have our
Yes. No. I knocked and I went into the room. Yes. No, I wasn't holding anything. No, other than my identity card in my pocket, I had nothing on me. The television was on. The television was on, and like I said earlier, I was on my way to my room. I said I'll pay a visit on him. And the television was on, so I sat down on the bed because he was sitting too, and I sat down and we're watching the television before he became agitated and asked me to leave the room. I was on my way out when he assaulted me. No, the first blow to my head, and I fell down. I was trying to get up when he hit me with the second blow, and I blanked out. Yes. Yes, I do. I was not drunk at all. Like I said earlier, I have taken some bottles of alcohol, but I wasn't drunk. Yes.
That's the leading question. So let's rephrase it so that answer comes out of his mouth.
Yes.
objection.
Go ahead.
After the second blow, I blanked out and I woke up in the hospital.
Good. Next attorney. Let's start over from the beginning. That's kind of where our facts run out. So start over from the beginning again. Yep. We don't have all that many facts to go through.
My name is John A. Smith.
Oh, actually, let's switch. I need a different victim so you have a chance to ask questions too. Very nice job, Private. Is there a witness? Okay.
My name is Private Jones. Private Smith. My name is Private Smith. I'm a military officer by profession. Yes, Private Jones. Private Smith. Yes, I know the accused. We are both in the same infantry. We are both military men and we belong to the same infantry.
I would actually take a step back. Since you've established they're in the group together, what's their relationship like? Do they like each other? Would they? Good.
Yes, on the day in question, after closing from my duty post, I went back, got home, changed from my uniform, and I went to the mess to relax. And then, of course, while there, I took some drink, alcoholic, just a few bottles. My church showed a couple of bottles, 3, 4, and I'm good. Yes. Yes, I took few bottles on this particular day, and at the point after relaxing, I decided to retire back home, and I was able to. I left the mess alone by myself, and I went back to the quarters. And when I got there, of course, instead of going to my room, I tried to pay Private Jones a visit in his room, just to also relax for a while before I retire finally to my room. Yes, we stay in the same barracks and on the same block. So we are colleagues and we are also friends. So I thought until that day.
Very nice. Next attorney.
Yes.
Nice job. Who's next up?
They are not. Yes, it has been cordial. We are colleagues and we've been friends. We're neighbors, we're colleagues, and we've been friends.
Next attorney up. Who hasn't gone yet?
About what? You can ask anything. This is direct. This is a direct.
You're only stuck with the facts here, but create whatever fits within it. She's saying 2 days ago they had an argument.
that that simply wasn't supposed to be. No, they said 1-1 now.
So we're just practicing a direct. If this were cross, you would chew him up on that. And you'd bring a witness to talk about that. But this is just for direct to get out their side of a story. But this is exactly what you can do with your own witness, create your own backstory to help support your self-defense. I like your story. I like it.
Okay, on this day in question, he was supposed to be on the duty post, but he closed earlier than he was supposed to close. And when our commander came back and asked who was supposed to be on that post, I told the commander he was the one, and he was sent to come back and was given overtime. When he discovered that I was the one that gave that information, it didn't go down well with him, and that was what led to the quarrel.
Good motive. Very nice. Everyone get a chance to ask?
Yes.
That is a really big question.
In relation
So,
to what?
pick which topic do you want to talk about next? I would pick one fact about it, either what happened, we still have to establish the severity of his injury. So you can talk about what happened from the hospital on, if that would help.
Yes, I stayed in room 110. Yes. Stayed in room 101, 101, and I stayed in 110, 107. Yes. Yes, like I said earlier, we are colleagues, we are neighbors, and we've been good friends up until that day in question. Yes. And also for the fact that
Ask
it a different way. Ask the same question in an open-ended way.
I was very surprised. Yes, I was very surprised because, as a matter of fact, my intention was also to go and make peace with him because of the earlier misunderstanding that we had. Yes, and he has been to mine. Not at all.
Good. Everyone get a chance? No. Okay. Defense. Witness was excused. Well done.
Thank you.
Okay, who's your... No, we're not doing cross yet. We're just doing direct. Cross we'll do later. I think cross is tomorrow. No, you don't get to chew them up right now. We're doing direct. Just a direct exam. So the state developed a theory of their case that these two individuals had a problem a couple days ago. And the victim was just trying to come in to be nice. But now you will be directing your own witness, and you can present your own theory of the case. Make sense? So we're just working on direct exam questions. Is there an assaulted individual? Sir? Who's going to be first attorney up?
Okay,
This is your own witness. Just direct.
Hello? You look tense.
Let me stop you for a minute. We're just doing direct today because sometimes asking the open-ended, broad question can be more difficult than cross. Because cross is where you're in your element. You get to tell people what to do. That's easier for attorneys. Direct can be harder to get your witness in a position where they can tell their story. And your job is just to help them tell their story. So don't be nervous.
You are looking nervous. Can you relax? No, I'm your hands and I'm here to assist you so that we can achieve the cause of justice. So feel free. So can you tell the court your name?
I'm Private Jones.
Private Jones?
Private Jones.
Okay, tell the court your name.
My name is Private Jones.
So what do you do for a living?
I am a private. I work with the army.
Where do you live?
I live at 178 Company A.
Okay, cast your mind to February of Friday, February the 1st, 19-ish, and tell the court what you can remember happened.
Okay, on the February 1999, a drunkard, Private Smith, came to my room. I opened the door. I never knew he was drunk, and when he came in, and I discovered he was drunk because he had a long history of being violent whenever he's drunk. I had to ask him to leave, which he refused. I asked him 3 times to leave, just to emphasize that I really mean it, because we are not friends actually. He lives very far away from me. It's in room 110.
All the way down the hall.
Yeah, or down where I'm in 111. So then he said...
You say he has a history of violence?
Yes, he's very violent.
Can you tell the court?
Yeah, he's a 19-year-old boy, so what do you expect?
Next attorney, very nice.
So it's expected. So whenever he drinks, he's very, very violent. And he actually has a nickname. We call him 33. Because there was a time he took 33 bottles of beer. So he was nicknamed 33. So when he came, I said, we should be married.
You guys have a really nice theme. Next attorney. Nice job.
Yes, thank you. Can you please tell the court what exactly you were doing when Smith, the drunk couple?
Little pressure and objection.
Okay, can I reframe that? Could you tell the court what you were doing when Private Smith walked into the room?
As a responsible soldier, at 9 p.m.
Cool.
I was in my room watching the TV.
You were watching the television?
Yeah.
So what happened next when you walked in?
When he walked in, I discovered he was very, very drunk, and it was annoying. It was obnoxious. So I asked him to leave my room. Then, because I know about him, he has always been like that. So because of the fear of imminent attack, I had to ask him to leave because whenever he's drunk, he's violent.
Okay. You said he particularly did anything that made you hit him on the head?
Yeah, he made it
back up
straight.
just a little bit, because you talked about, he said he's drunk and obnoxious, and I knew that is just a ton of information there.
Yes, yes.
That's like this,
Yes.
and we want to bring it down.
Yes.
Tell me, what do you mean drunk and obnoxious?
Exactly.
What was he doing?
Yes. What do you mean by being obnoxious?
I mean, he's very, very annoying.
How annoying? What exactly is annoying about him?
You know, he was misbehaving in my room.
What is the misbehavior?
I asked
Just
him.
be particular.
Yeah, I asked him to leave 3 times. Then he threatened to kick my ass.
Okay.
Well, okay, that's great, but when you're talking about, he didn't really answer your question. He's being obnoxious. Is he ripping things off the wall? Is he throwing pillows across the room? Is he peeing on your wall?
Yeah, he was spitting. He was.
So all these things that are just completely obnoxious.
Yes.
So when you're talking about, you're trying to get to the heart, he keeps using a different word. No. But what was the behavior? You've labeled it, but what was the behavior exactly that bothered you?
What was the behavior that
You did a nice job of following up. Next attorney. Very nice job.
Mr. Smith, you described the Jones being drunkard. Can you tell the court what? How did you arrive? That was what he said. That was what he told the court. That was the first question.
You guys have a lot of leeway. We'll work on cross next time, or no matter what they say, you guys get to pick at them. That's the more fun.
You refer to him as a drunkard and a
Yeah, like I said earlier, I said Jones has been nicknamed 33. He has a history of drinking, you know. He was nicknamed 33 for drinking 33 bottles of beer, you know. And on that particular day, was having that he actually took 8 bottles of beer before coming to my room, and I can see this in his behavior when he came to the room.
How did you come to the conclusion that he's a dangerous man?
Yeah, he has a long history of being very, very dark.
Instance.
Oh, there was a time. There was a time we were on the field, we were practicing, and the commandant actually corrected him not to run too fast. He actually, you know, hit the commander with a single blow, and the man was off.
With a single blow?
Yeah.
Good, next attorney.
Mr. Private Jones, you actually said Smith is obnoxious. Obnoxious means being unpleasant, harmful, irritating.
You're testifying.
No, I'm not saying.
It's your question.
That's what the meaning of what he said.
Okay.
Obnoxious means being harmful. That's what he said. It's very irritating act. Can you please tell this honorable court what you actually meant by being obnoxious?
Good.
Yeah, that particular day at about 9 p.m. when he came to
What
my
is activity?
yeah, that's what I'm saying. He came to my room. He was very, very loud. He was making a hell of noise. He was spitting, spitting in the room. He was organizing the room and almost threw away my TV.
Soldiers are trained to kill. That's established. Soldiers are trained to kill. Yes, soldiers are trained to kill. Excuse me. Soldiers are
But that
trained
is
to kill.
testimony.
Another soldier.
You want him to come out that he is trained to kill and they are trained.
You are trained to kill. Isn't it, as a soldier? And when a further soldier and a silent soldier attacks at you, what do you feel? What do you feel? You feel protected.
Wait.
No, he said this. He said he threatened to kick his ass. He threatened to kick his ass. Alright? He said he threatened to kick your ass. And when a soldier tells you he threatened to kick your ass, what will you interpret that to be?
Well, it is true that soldiers are trained to kill.
Let me stop, because that's a dangerous question to ask your own client. Because if your client is sober and the victim is drunk, then of equal training, the sober guy is going to prevail. So you want to be really careful.
So what I'm trying to establish now is that threat. A person who is actually trained to kill, when he's drunk, he's actually aggravated.
Right.
So he can actually do anything. Of course, a person who knows that the next victim, just like a next victim can attack and kill, the next victim is defend. Yes.
You can talk. I would talk about what training they've had together, that they've both gone through different defense and offensive techniques. But I think going down the line of because he's drunk, he's going to win. A lot of the techniques that my officers talk about are very precise maneuvers, and that when they're drunk, they don't have the same reaction time. So I think that's a dangerous line because the state's going to jump all over that and say, yeah, they have equal training, but one of them's drunk and he can't think as fast. But if you want to establish that they're trained killers, then that needs to come out of his mouth. And that's the hard part about direct is all of the information that you want to get out, you have to get through his mouth. Because then they don't have a way to object, and the court hears it directly from your witness. I'm going to have to swap out my offender, my trained killer. Who's my next trained killer? I need another killer. Okay.
Come on, be a witness.
Now we have a new trained killer.
Madam is not here.
Nope.
Well, there have been instances where Private Jones has attacked so many of our colleagues on instances like this. And about 2 or 3 occasions, those are our colleagues, I have to say, they sustained several injuries. So when he came to my room, I was scared, because at the time, as a responsible soldier, he should be in his room. So when he came to my room, initially I didn't know he was drunk. But when he got close, I found that his mouth was dripping for alcohol, and at that point I already got scared, considering his antecedents. So I told him to leave, and he insisted that he had to stay. So at first I left him, and then he started approaching me. And those were the instances that he hit our colleagues. So I had to be proactive. That was why I hit him. No, the first time. I hit him the first time. And he's a very, very strong soldier. After the first time, he didn't fall down. He stood up to me. I had to hit him the second time. And then...
So your guys' theme is that this is an enraged, bullying, trained killer that has already menaced the entire division. Good. And you guys have that, the theories that you've developed so far, I really like. Okay, next attorney.
Let me try. I'm going to start.
Wherever you like.
My name is Private Joe. I'm a soldier.
Hey.
You got to ask more questions to get that description. So there was questions about going into the room, but there was no questions about, well, where was Jones located in the room? Where Mr. Smith, when you went into the room, where was Jones at? He was on the bed watching the TV, and you talked about how after you were watching TV, what did he do? Well, he asked me to leave. And where were you at? Well, I was sitting on the chair next to the bed. And when he asked you to leave, what did you do? Well, I stayed sitting in the chair. I was watching TV. I thought it was cool that I was in there. And then after he asked you to leave, what did Mr. Jones do? Well, he got up and he went over to the desk. And how far is the desk from the bed? I don't know, a couple feet. So but he had to actually get up and walk over there. And when he walked over to the desk, where were you at? Well, I'm still sitting in that chair. I'm still watching TV. So you're painting this picture. You want to illustrate it for the court. You're painting this picture. And then, did you ever get up off your seat? Well, after he went over to the desk, I decided to get up because I thought, well, maybe it's time to go. And then what happened? Then next thing I know, I'm walking out the door, and I get hit in the head. Okay, Well, you said you're walking out of the door. Where's the door located on that in that room?
Yeah, the bed.
It's the doors, on the left side of the bed. So would Mr. Jones have to get from the desk? Would he have to go past the bed to get to the door? So you have to start painting that picture. Then in your materials you have a diagram. So anyone want to take a shot at painting the picture through the diagram? Because Demi was talking about what's called the 3-pass method. So a 3-pass method is, so the way I usually do my direct examination, I'm going to paint that picture through my questions. So I'm going to go through it, I'm going to paint the question, I'm going to ask very detailed questions. So some of the questions, I'm going to ask Mr. Smith, well, who else was in the room with you that day? The only other person in there was Mr. Jones. We've got to establish that there's no one else out there, because that throws the defense out. Let's establish no one else is in there. We might even talk about the lighting in the room. What was the lighting like in the room? Well, we were watching TV. It was pretty dark in that room. None of the lights were on except for the TV, so the only lighting was the TV. So start to paint that picture. So when you're doing your direct examination, you want to take it's almost step by step. You're painting by number here. You want to have detailed questions that paints this picture. You got to almost assume that the judge knows nothing. If you're going to tell a story to someone, almost like, okay, I'm going to repeat this story between Smith and Jones. No one else knows about it. How do I paint that picture for someone that has never heard of this story, that they can picture it in their head? Like they're almost seeing it. We have to have a level of detail where they can see that. So you have to almost assume that this person knows nothing about this. And so let's go step by step and go through this. All right. So now our setting is we're going to have, so we call this the 3-pass method. And this situation is we've done that first round of direct examination. So we've asked some initial questions. We painted the picture through those initial questions. Now we want to make sure, like I said, repetition is the best way to learn. So we want to repeat this, but is the judge going to let you ask the same question over and over again? So, Mr. Smith, you got hit in the head with a sharp object. So, Mr. Smith, you got hit in the head with a sharp object. So, Mr. Smith, how many times did you get hit in the head with a sharp object? So the judge is going to say, asked and answered. The defense is going to object, asked and answered. Move on, please. You've already asked that question. I think we know you got hit in the head with a sharp object. So how can we get that same information, that repetitiveness? All right, so instead of asking it a second time, we're going to use some type of demonstrative exhibit to be able to represent this evidence. So let's use the diagram to then allow us to represent a second pass at this, at presenting this evidence.
That's where you should pin. That is where you should do. Pin it to a particular place. For instance, if you have pinned it here, then it will mean when he was going out, he was seated here watching the television.
Okay.
He must be here watching the television. This is
so what we have. Okay, let's go back to our fact pattern, because we're limited to. Remember, we're limited to the evidence that we have. So this is our evidence. It's not a very good report, but it's our evidence. So we're limited to this. So let's look at this. Okay, let's look at it real quick, and let's see what we can find in there that shows, that answers some of those questions where he's at. So go ahead, take a second. Let's look at it. I'll look at it too.
timing to create this. Tebur din ana a ganye tashi zai fita ainihin zai fita ko so kaga it means
Okay.
you can't establish it's coming towards.
So it doesn't give us a whole lot of information. So I'm going to supplement it through. Let's say that during direct examination, Smith says when he went into the room, Jones was sitting on the right side of the bed. Okay, this is what happened. This is through the first pass during direct examination. Jones is sitting on the right side of the bed. When the TV is on the oval table in the middle of the room. So the oval table.
Okay, over.
And so and Jones was sitting in that middle bed, the bed that's in the middle of the room. When Smith came in, he sat on the left side of the bed towards that back wall. You see that? So on the left side of the bed on the back. And at some point, after Smith refuses to leave, Jones goes to the desk closest to the window. And the wrench was in that desk. Smith then gets up and walks towards the door, and then Jones approaches him from the back as Smith is walking towards the door. All right. Does someone want to try using the diagram and doing something similar to that with Smith? Me, Smith being the witness. Anyone want to take a shot at it? So, go ahead and introduce the diagram.
Mr. Smith, you informed this honorable court that you were seated. When you came into the room, the accused person was seated on this bed.
Let's do it like this. So show me the diagram. Okay. So show it to me. So okay, and then ask me.
This is the bed.
Okay, hold on yet. So ask me, what is this?
Okay. So you have informed this honorable court when you came into the room, the accused person's room, that he was seated on the bed, extreme end bed. The bed in the middle of the room. Is that what you said?
Hold on. So we're getting into leading questions on this. So let's do it this way. So
where exactly was the direction of the bed the accused person was seated when you came here?
Okay, let's do this. So show me the diagram, and then so ask me, what is this? Just ask me this type question. What is this?
But can I do that when the diagram is already not in the courtroom?
Because we haven't shown. All we're using is for a demonstrative. So just ask me what that is.
Okay, what is this?
This looks like, from looking at this for the way the beds are set up and the desk. I know this. This is a diagram of Jones's barracks.
Good. Thank you. So from this diagram of Jones's room, where exactly was John seated? Or
Okay.
where did you find John when you entered?
Okay, what happened is, I came into the room. Jones was sitting on this bed right here.
Yes. This bed right here.
Yes.
That was what.
So when you ask me what it is, then he should move to the. Your Honor, may I use this as a demonstrative exhibit? Yes. Yeah.
So assuming that hurdle had been crossed, can we proceed?
So we're going to assume it's been, the judge allows this in because Smith gave the necessary testimony of the foundation of he knows that this is a diagram of that room. So Smith has just said that Jones was sitting on the right side of the bed.
Yes.
Okay, now what do you need to do once Smith says that?
Yes.
So, or once I say that as the witness,
Yes.
can you guys have a court reporter when you're doing a trial?
Whether we have.
Normally we don't.
You don't?
No.
Okay, do you have, is it recorded?
Long time. From Imperial Court to Supreme Court.
Okay. So are they recorded at all though? Is there some type of record that's made during?
The judge's record.
Okay. So you want to say something for the record. The witness has pointed to the bed next to the wall.
Yes.
So establish. So even though the witness said that, you want to establish that for the record. So the witness has stated that that Jones was sitting on the bed that's next to the wall in the middle of the room. Okay.
So I will now say, Your Honor, the witness has identified the position where Jones was seated when he entered the room, which is this portion. I will now show the court. Now I will ask the witness, where exactly was the television when you entered?
The television was right here on this table. It's kind of slanted because there's two beds in there, so it kind of, both people could be watching the television at the same time. So it's right on this oval table.
So, Your Honor, the position of the television has been identified by the witness, which is on the other oval. Who identified the position of the television, which is on the oval table in the middle of the room. Now, when you came in, you sat down which side of the bed?
When I came in, I came all the way across the room, and I sat on this bed.
So you sat on this bed. The witness has identified the second bed on which he sat down when he came into the room. Now you said while you were seated watching the television, the accused person asked you to go out, right?
Correct.
Right. Now when you refused to go out because you were watching the television, you went to the desk and picked...
Wait. Don't. You're leading me there. So
what did the accused person do?
Okay, that's exactly. So what did he do? Exactly. What did he do? He asked me to leave, and then when I stayed in there watching television, he got up from the bed and went to the desk.
Yes, which of the desks in particular? Where is the desk located?
This desk right here.
So, Your Honor, the witness has identified the desk on which the rake was laying. So when he went to the desk and picked the rake, what did he do with it?
Again, be careful on the leading on this. So.
But it has already been established, so it can't be leading. You have already given evidence. I want to
remember. My testimony is because we're not in redirect. We're still in direct.
Okay.
My testimony is I got hit in the head with a sharp object. So the question is, did you see what he picked up from the desk?
Okay.
So you could ask that.
So when he came to the desk, what did he pick?
I don't know what he picked up. I just saw him. He went to the desk.
Yes. So you don't know what he picked. So what were you hit with?
So hold on. We're still painting this picture. So after he went to the desk, what did you do after that point? What did you do after he went to the desk? So that's we're still trying to paint this picture. So ask me that question. What did you do after he went to the desk?
Okay, what did you do after he went to the desk?
At that point, I decided it's probably time to leave, so I started walking out.
started walking out, and then what happened?
Okay, now this is a good time to show me on the diagram. So when you walked out, did you have to go by him on that desk?
Automatically. Okay, let me see. You informed the court you were seated on this bed.
Yes.
And that you said you went to this desk.
Yes.
And then you decided it was time to go out. Now, if you were to go out, where will the door be located?
Okay, so when I got up, so you could ask, how did you then leave? How did you then leave the room? It's one of those questions that, yeah, it makes common sense that the person should know, but we still had to paint that picture. So I want to get Smith to say, I got up off the bed and I started walking towards the door.
That was what I said. Okay. So what did you do? You said you started walking towards the door.
Correct.
Yes. So tell this honorable court where the door will be located.
The door is up in this portion of the room. Now, now tell the court where I just pointed to.
So this, the witness has identified the position of the door on this diagram, which is here.
Up in the, give some, up on the, what is it, the top right-hand corner of the diagram.
On the top right-hand corner. Now, I will be correct from what you said. The evidence is already before the court. I will be correct to say you were at the extreme end. The accused person was in the middle, and the door is behind. So I will be correct to say you have to pass the accused before you reach the door.
Yes, but ask it. That's a leading question. So we have to.
It can't be leading, sir, because you already established. It's already established that what is in Nigeria. What we have here is that whatever is already before the court is deemed as proved. So you don't need to prove it again. It's already an established fact.
Diagram.
So, but even if it is,
we are taking it again. It's not before the court. We want to just paint the.
No. I said what I'm saying is that it has formed part of the proceedings. That he was seated here, the man came here to pick the whatever object, and that the door is here. It has already been established. And then he has decided he was
regardless of the reason we want to do this is because we want the witness to paint. How's it more? Is the judge going to take greater preference to if you're the one telling the story, or if the witness is telling the story? We want the witness. We want the witness to tell the story, so that we have to frame our questions where instead of me telling the story through leading questions, I'm letting the witness paint that picture. I'm allowing him. I'm the paint. He's the paintbrush. So we're allowing him to actually complete the painting by saying, okay, after the question would be after he went to the desk. And you said you were walking towards the door. Where did the defendant go after that? The next thing I know, I'm walking out the door, and he comes up behind me and hits me in the head. See how that paints the picture better? And then.
But from the evidence, but from the story we were given, it wasn't like that. It was that the accused person saw him approaching him. And because of that,
that is the story. That is the story. We're talking of
that's the fact of the case.
Now it is Smith's story.
Yeah, we're Smith's. So and then so we want to establish and then what after you got hit in the head? What happened after you got hit in the head? Well, I continued to walk out that door, and I got hit in the head a second time. And then where were you at? Show me on the diagram
where you were at.
And when I got hit in the head the second time, I was out the door. You know.
The non-justification for the second.
So I was in the hallway by that time, and so then you let the court know that the witness said when he got hit in the head a second time, he was in the hallway,
right outside the.
And then what happened? Then what happened after that? Then some of the other guys that I had been drinking with came down the hallway to see if I was okay. And then I ended up, they took me to the hospital. So you have to frame the questions in a way that you're allowing the witness to answer it. I mean, it's easier for us to ask the question in a way that we're going to get an answer that we want to get, and to say this is what happened. But what we need to do is ask the witness in a way that it's a question that they're allowing us to paint that picture with. So we want the testimony. We don't want the testimony to come from us. We want it to come from the witness. We want the witness to be able to fill in those blanks for us. So we have to ask the question in terms without it being a leading question, where we could say, what did the defendant do after you got up? See, there's nothing. I didn't tell anything in that situation. I'm going to let the witness complete that and give that information. And that helps to build credibility with this witness. If not, then the judge is going to be sitting there saying, well, who's the victim here? Is it the prosecutor or is it the witness? So let's, I want to, the judge might even say, I want to hear from the witness. I want to hear his side of the story. So we'll get the chance to. This is just, but when you're going through this Castro case, draft out. I know you just had a short time with this, so it was kind of quick. You didn't have a lot of time to prepare for it. Draft out some questions. I never draft out all the questions I want to ask. I want it to be a fluid situation. I want it to be a conversation. I want to be able to react to information. But I also want to be able to put some bullet points in there of key information I want. I want to establish he was out in the hallway when that second hit occurred. So I want to establish he was in the process of retreating. And frame these questions in a way that that the witness is able to answer. So we're going to get this chance to do this again tomorrow with the Castro exercise. So when you're going over it tonight, start thinking about how you want to frame those questions, and start framing them to get these broad, painting this picture in detail. And I think we're done with this breakout. So thank you. Thanks for the participation.
That I understand the scenario differs in our legal system here. What we are used to is part of it, but we have understood what you are trying to emphasize.
It is better if whatever is said comes from the witness.
Yes,
exactly.
But
So
in our own system here, once you testify in the examination in chief, now this is what I mean.
And you can a little bit. So this was still direct examination. So it's still direct. You're just doing it a second time for the witness. And there's sometimes you're going to do a little bit of, you're going to fill in the blanks a little bit. Well, you really want to focus on trying to
create the picture himself.
Correct.
So that you will not be seen to be too repetitive in the process.
Yes. There's a question back there. Yes. It's going to be opposing counsel's going to object. So where do the objections come from? Is it opposing counsel that objects, or is it the judge that?
The opposing counsel.
Okay. Yeah.
Even the judge can say it's illegal.
So a lot of times, I push the envelope. I'm the type of guy. I'm going to lead most times until probably counsel objects. That's just the way, if they give me a little bit of leeway, I'll take it a little bit. But again, I want the witness. I really want the witness to be answering most of the questions. Because it just gives you a lot more credibility if the witness is the one that's establishing it.
Also, I am a little bit confused on who plays a major role between the jury and the judge. Because in our own system, we only have a judge.
Yeah.
He's the alpha and omega of everything.
Yes.
But
So really, in the U.S., like if you're in a jury trial, just to give you kind of some background on how that works. So if you're in a jury trial, really the only role that the judge is playing is to rule on objections by the parties. So really, that's their main function at that point, is to make sure that that the parties are playing fairly, I guess. So really, but all the decision as far as guilt or innocence is made by the jury. So really, I'm not trying to. When I'm in a jury trial, I don't care about the judge. All I care about is I want a judge that's going to allow me to ask certain questions or allow me to get into the evidence that I want to get in. But I'm not trying to convince the judge. I could care less if the judge agrees with me or not. All I care about is the jury. That's all I care about. And when my witnesses answer a question, they're going to face the jury. So if they're sitting on a witness box, I'm going to ask you the question, then I ask my witnesses to then face the jury and not the judge, not me. You know, it's natural to face each other, and I'm asking questions. It's natural for you to respond back to me, but really your witnesses should probably be responding to the judge, because that's who you really want them to be talking to. You're basically asking questions for the judge, and the witness is telling the judge what's occurred. So, and that's the same thing in the U.S. I'm asking questions, and I want the witness to turn to the jury and address the jury and answer the questions that way. So, yeah. Yes. So if opposing counsel, let's say opposing counsel says objection, leading question, the judge might say, yeah, I don't, yeah, it overruled because it's not really affecting anything. You know, it's kind of, you know, I did a trial once, and the defense attorney told me, it was actually my first jury trial that I did, and it was a first felony. I had done some misdemeanor jury trials, but first, like, major kind of case. And the defense attorney, it's the drug case where his client threw the drugs up in the air. His client had no chance in the case. But he said, he told me ahead of time, I'm going to object to every question you ask. I'm going to be a complete jerk. And I'm going to object because he's like, that's all I got. I don't have much to work with. So he kind of warned me ahead of time. He's like, it's nothing personal. I'm going to be a complete jerk during this trial. So nothing personal against you, but I'm going to object to every single question. And so I got in there. They would like to call Detective Ellison with the Department of Public Safety. Objection! You know? So, leading question. You know, the court's like, you know, this is, you can call your witness. You know, you get the chance to call your witness. And then, could you state your name for the record? Objection. You know, literally, like, almost every question he objected to. So it's, you know, he was just trying to make it as difficult for, he was hoping that maybe it would distract me. Yep, and that I maybe miss elements through the course of it. So, and you know, every single thing, then occasionally, like halfway through, he'd ask for a mistrial just on some random stuff. Objection, mistrial, you know. And the court would say, approach, because what's the mistrial? And then he'd come up with some crazy theory or something. So, but yeah, so the judge can start saying, you know, those questions are allowed. You can ask those questions. So the judge has the discretion to allow certain questions to come in. What's that? No.
Discretion.
Discretion, yep.
Discretion. Just like our duty.
Yeah.
It depends on what
yeah.
you think.
Particularly as you present
Uh-huh.
Can they in a circumstance as reasons that relates to a gray area that they are not clear about?
So that's a very good question. The question that was asked is, in a jury trial, can the jury ask questions? So all I'm familiar with is Arizona law, because that's where I practice. So under Arizona law, the jury can ask questions. They're not limited they're limited to the rules of evidence. So what will happen is, if the jury has questions, typically what will happen is the parties will go through all their questions, and then the judge will turn to the jury and say, does any members of the jury have any questions for this witness before they're excused? And then they'll write down the questions. Those questions are then folded, handed to the judge. Then the attorneys go up and approach the judge. The judge reads over the questions and then allows the parties to make objections if they feel like there's some evidentiary reason they shouldn't be able to ask those questions. So they're bound by the same rules of evidence, but yeah, they can ask questions. So it is an interesting process that they can ask questions. So, any other questions or anything? Thank you for the role playing. I like the participation. The more you participate, the better. So I appreciate you thinking. I hate role playing. I'll be honest. So I would never volunteer. I'm the guy that likes to sit in the back and I'm not role playing. I'm not getting up there and let everyone scrutinize me for what questions I'm asking. So I appreciate you guys doing that. That takes a lot of guts to do it. So especially, I'm more comfortable asking questions in front of a jury and doing an actual jury trial than if a bunch of my peers are watching me, because they know what you can and can't do. So I appreciate everyone that participated, and so work on that Castro case. I think we have one more presentation, and then let's see, by the time we're done with this. Well, I guess we're till 2:30. So I guess any other questions? Oh, what? No.
My law enforcement and the work that they've done and the evidence, and I prosecute those.
I have this is not exactly on this topic, but
now on the outbreak, how much is dedicated to investigating? For instance, the crime that is cross-border has to do with big mobile issue. How much does the American government invest in trying to resolve it?
I don't know that I have a set answer for you. In each state, there are counties. Each county is responsible for the crimes within that county. So I have local police, I have a sheriff's department for the county, and then we have Nebraska State Patrol, or the state police. The state can investigate anywhere. Local police can only investigate in their small town. County can do the whole county area. State can do the entire state. Feds can do the entire nation. So if I have something that goes across county, thieves always go across county. You can only steal so much from one place before they're out. Either our county officers will investigate, or if there's more counties that we can do, or they need to see. And then that can be prosecuted either by the state at the state level, or any of the counties where the theft took place. Does that make sense? And then what the feds take, they take what they want. If they want the case, it's big enough, they'll take it. Yes, sir. Yes. They don't have a typical swearing in like an adult would. So raise your right hand. Yes, right hand. Place your hand, swear to tell the truth. We have a different validation process for kids to testify, and I've had as young as age 4. A judge will typically talk with them, usually outside of the presence of a jury. If we have a jury, they'll ask, do you know where you are? Do you know why you're here today? Do you know what it means to tell the truth? Do you know what happens if you tell a lie? If some jurisdictions go through a picture process where, this picture shows little Timmy knocked over a vase and blames it on Susie. Is Timmy telling the truth? So, and some jurisdictions, just the judge will ask certain questions. If you take a toy from a friend of yours, what do you need to do? If you didn't tell the truth, what would you do? So each judge has to determine that the witness in front of them is competent. And different judges do different things. I won't file a charge if all I have is a victim report. I won't file it. I don't know how that gets beyond a reasonable doubt, because the different standards in the United States is clear and convincing, which is maybe, preponderance, which is yeah, probably, and then there's beyond a reasonable doubt, which is yeah, we're good, and they're all squishy terms, because we don't have, I can't say 51% I believe you, and then beyond a reasonable doubt is 95%. We don't have a number. It's beyond a reasonable doubt. And when you have the word of one person versus the word of one other person, I don't know how you get to one side. And if you're stuck in the middle, you must go not guilty. So I won't file a charge unless I have a report plus something. Physical evidence, documentation, other witnesses, video, something. So yeah, if it's a one-on-one, I can't imagine someone being convicted. No jurors will be called if it's a plea bargain. So to give you an example, I think I have 175 cases right now for me. So I've got, in October, I think I only have like 10 or 12 set for the 3-day period. In November, I have 22 cases that are supposed to go to trial on the same day. My judge has 2 other counties. So there's 60 cases approximately set for trial November 15th. We can't try all of those the same day with the same judge. Right. They're not all going to go. But we're all set that one day. They all have to be ready to go that one day. Defense can continue it, or a defendant can accept a plea agreement. And typically the closer to trial we get, those who are guilty and just didn't want to plead, they're like, I don't want to go to trial. And those that we have evidentiary issues, those are more likely to go to trial. I try to make a plea agreement that I think is fair to society. I'm not trying to just be punishing someone, but I want to make sure that someone doesn't come back to see me again. A lot of people come see me. Nobody likes it. A lot of people come see me. So what does it take so this person doesn't come back to the court? We have a lot of addiction issues. We have a lot of mental health issues. And we have a lot of poverty issues. So no job. They don't have a job. They don't know how to get a job. They're going to steal from somebody. We can fix that by education and getting them training skills. Maybe they won't come back. Addiction, getting them treatment. If they're addicted to drugs, they run out of money, they're going to go steal something. Or it's the people that enjoy hurting others, those are going to go to trial, because I'm not going to give them an offer. The people who enjoy molesting 5-year-olds. That's why we have prison. But people who have issues that we have a way to try to help, those are the ones that are probably going to be plea bargained, because they have taken steps to show me that they're not a danger to public anymore. They've made restitution. They're trying to make it better. And so those are the people I want to help along that way. If they're willing to work at changing whatever the problem is, I'm willing to help them. Yes, sir.
Tend to get matters concluded on that day.
Okay, so November 15th.
Very serious matter.
Right.
Do you give just beggars, present this case, get witnesses, and then you know with
Ask me again, I'm confused.
No, you say you're having 22 cases in one day.
Right.
And they're likely to get judgment.
No. Most of them will be resolved before trial. Either their attorney will ask for more time, or they'll take a plea agreement. If they take a plea agreement, then we'll do sentencing 30 a month to 2 months down the road.
How about we have a different one?
Then we'll probably have, I'll probably have 3 or 4 left that actually want to trial.
What trials are likely to take after?
Most trials, I think the longest trial I have would be 5 or 6 days in a row. Yeah.
Including defense? No.
Including
So,
motions, objections.
yeah. Well, motions will be done before trial. Evidence issues will be done before trial. So just trial itself, picking a jury, being in court with the judge and the jury, 6 days.
Every day.
Yeah. It's hard because, like I said, it's exhausting. But, and I tell my jurors, okay, or my witnesses, I need you all this time.
But they're still doing it. Actually, they're still doing it. They just can't stay considered. But what happened? They went to appeal. And they just school court under the permission. School court made order that
I can't status such as that.
Saratitis.
Yes.
But of course, it's still possible. But when
We still have defendants that meet the system. I can't force a defendant to go to trial. I can't force a case to go. It's the defendant's right to have a speedy trial for 6 months. I can't make it go. So I have I have a lot of kid cases that I have one case that's 2.5 years old. I just got it resolved. And my child went from 7 to 10.5. They want to be done with it.
Back in an hour's time, Princess Chuku Annie. Thank you so much. And then somebody walked in during our breakout session, and that is Marcus Green. I will leave him to introduce himself as I invite him to come and talk to us about CWAG AAP. He's our coordinator, and he will tell us more about. Please let us give him a round of applause. He's just coming off a plane right now. His plane was delayed. That was why he wasn't here to give his opening speech in the morning. So, ladies and gentlemen, let me welcome Mr. Marcus Green.
Can everybody hear me? I won't use the microphone. So good afternoon. Oh, come on. We can do better than that. Good afternoon. Good afternoon. All right. So it's great to be back here in Nigeria. I feel it's become my home away from home. Okay, sure. I was told that I have to use the microphone for live streaming. Technology gets in the way. So I'll use the microphone. So it's good to be back. It feels like my home away from home. In fact, I was going back and forth to the region for some time, and I said this place just feels comfortable to me. And so one Christmas I got as a gift, I received Ancestry.com. How many of you have heard of Ancestry.com? It's a company that basically you send your DNA away and they trace your lineage. And it turns out 40% Nigerian. So I'm going to talk to you a little bit about CWAG. CWAG is the Conference of Western Attorneys General. It's an organization that started off comprised of about 15 states, working mainly with the Western states. And then they've expanded over a number of years doing training and information sharing for state AGs in the U.S. So now CWAG has just about every state as a member. And as part of CWAG, they branched out and they've done some international work, mainly in Mexico, doing training, trial advocacy, similar to this. And so a few years ago, we came up with the concept of why not doing the same type of training, same type of outreach effort on the continent of Africa. And that's how I got involved in CWAG. So I work for a company called Pfizer, and I'm sure you're wondering, okay, what's the connection, Pfizer, CWAG? Well, it's basically CWAG is an organization that is the best example of the intersection between the private sector and the public sector working together to do important work such as trial advocacy training, such as issues related to human rights, corruption. And so as an employee of Pfizer is a company that sits on CWAG's board. And so I head the African Alliance Partnership for CWAG, and it's just been kind of a fantastic experience. We've had incredible folks being very receptive to the idea. We're in about 9 countries now on the continent. Zambia, now we recently made a relationship with Uganda, South Africa, Nigeria, Kenya, and the list goes on. So we're working really hard. And my personal background, so what you're doing here is near and dear to my heart, trial advocacy. I was a prosecutor in Manhattan for about 5 years. I served in the Attorney General's office in New Jersey as the chief deputy for 4 years. So this is extremely important work. I still remember the first day of law school and having to take a trial advocacy course, walking to the room, and the professor said, I'm going to teach you how to break the silence of the room with the sound of your voice. And it's always stuck with me. So as advocates, as prosecutors, whether you're on the prosecution side or the defense side, the obligation is the same, right? It's the facilitation of justice. And so it's really important that you're here today. I really appreciate the attendance, the engagement. I saw some of the breakout sessions. I definitely want to give a special thanks to Demi Herman from Nebraska, as well as Scott Blake from Arizona, because they traveled a long way to be here with you. And I really appreciate you guys giving them your time and attention. And so this partnership between CWAG and the continent of Africa is growing. And so I just wanted to let you know that you're a part of something larger than yourselves. That's something that's extremely important, and something that speaks to the kind of global village, because there is a connection between what happens in the United States and what happens in Nigeria. There is a connection between what happens in New York and what happens in Lagos, Nigeria. So all of these issues are very, very important. We do another kind of setup or seminar program, which is more on the line of a panel. We do issues related to human rights, human trafficking, issues related to corruption, and those are more in a panel format. This is more or less training and an exchange of ideas on how to approach oral advocacy. So I want you guys to have and really embrace this session, really take advantage of the talent that you have before you, ask questions, continue to be engaged, and really hone your skills, because our system of justice, the collective system of justice, depends on all of you, right? You guys are lawyers, you're advocates, and if I have to give you one piece of advice, is don't be afraid to break the silence of the room with the sound of your voice, right? You ever walk into a courtroom or you meet a lawyer and he mumbles his name? All right, it's ineffective. You're advocates. Be unafraid. Speak up, stand up, and do your jobs, right? And don't be afraid. Don't be afraid to take some risk, whether it's in a courtroom or in the writing of a brief. Your job, you guys have all bench trials. That means the judge is listening to you. So your job is to marshal those facts in a way that a judge understands your position, and do it completely unafraid. So thank you all, and I wish you a fantastic training. And if you have any questions, I'll be milling around between today and part of tomorrow. So thank you very much.
Very wonderful. Never be afraid to break the silence of the room with the sound of your voice. You know, that reminds me so much, and I was privileged, I'm still privileged to be in local attorneys and solicitors, and I know during our Friday lectures we usually have young lawyers come in, and then these young lawyers, we have Friday conference, and during our Friday conference you are told, okay, what did you do during the week? And then you're supposed to, you know, recount what you did. I went to court, this happened and that happened, and then when you're talking, everybody just keeps quiet, and then you finish, and and my senior partner asks, did anybody hear her? Everybody of course says no, and then you have to repeat until your voice is as high as he wants it to be, because a lawyer is not, no lawyer should have any excuse for not speaking out boldly, because that is our profession. We are advocates. Advocates cannot mumble, you know, and that is why all these seminars are very, very important. It gives us an opportunity for us to do what we're supposed to do as lawyers. Thank you very much again, Mr. Marcus, for coming all the way. So we are going to take the last paper for the day before we go for our lunch. After the last paper, we'll just go for our lunch and go back. But before we do that, I want us to note, I don't know whether you have been able to download the material from the website. The case we are supposed to use for tomorrow is in the material, the case of Castro. It starts from page 1 to 27. If you are online, you can open it. It starts from page 1 to 27. The case of Castro, that is people against Castro. That is what we are going to use for tomorrow. It's quite long. It's 27 pages. So it's good for you to go back and read it, so that tomorrow, during the 15 minutes you're going to be given to read it, you will be able to grasp quickly. But if tomorrow is the first time you're going to read it, it's not going to be easy for you. But read it today so that tomorrow you're very prepared for what you are going to do. And then the next paper is supposed to have been taken by Chief Anthony Idigbe, but I have his sincere apologies. He said I should extend his sincere apologies. He was not able to make it back to Nigeria on time for this lecture, and he has asked that I fill in his big shoes. Those shoes are rather too big, but I hope I do justice to that paper. And if I don't, I know people are here to help me. My people are in this room, Abby. My people are here now. Thank you so much. And the paper, I know even if nobody takes my side, I know Professor Agom will run to my rescue. So this paper is presenting evidence. Presenting evidence. Like I said, I'm not the owner of the paper. My boss is the owner of the paper. So I'm just going to run through the paper. And if you have any question, I know we are here, we'll take it together and we'll answer the question. Thank you very much. And presenting evidence. You know, one thing about a lawyer that we'll get to find out in the course of this paper is that preparation is everything to a trial. Preparation, you can't take it away from a trial. From any successful trial, preparation is very, very, very important. If you don't prepare, of course, along the line you will find out that it's not going well. But if you do your adequate preparation and you present your evidence well, of course, you are sure that you have done what you should do as a lawyer. Even if our work is not to win cases, our work is to do our best as lawyers, to do what we are expected to do, to make sure that no stone is left unturned in doing our work. Thank you. And we are going to be looking at civil litigation, but maybe a little bit of criminal litigation. And of course, in preparation of presenting evidence, of course we know that we have cross-examination and we have been having a lot of direct evidence. And I will leave the aspects of cross-examination because tomorrow we'll have Mr. Fola Atowori here to take that his part of his paper. But generally in commencing civil actions, there are several procedures we know. In Nigeria we have the writ of summons, the originating summons, petition, originating motion or application, and it is commenced by a writ of summons. Which one? The one that we're going to be looking at really is writ of summons, because that is where we have presenting of evidence, as in having a witness and doing all we are supposed to do. Because the other ones, of course, we know is paper evidence. Is not really things that we actually go out there, have a witness stand there, and the courts evaluate a witness. So the ultimate goal is to understand general civil litigation procedure in Nigeria and trial preparation. Of course, we are going to look at a template and the role witnesses play in achieving success in litigation. No matter how brilliant your case is, if your witness is not prepared, if your witness is not prepared to give evidence, that case is going to fail. If you have a witness, like we discussed here, that comes and forgets his or her name, it's going to be difficult for the witness to be able to give evidence in such a way to convince a judge that is actually saying the truth. So we need to be important, we need to understand the role a witness plays. And of course, trial procedure and silent issues which cannot be overlooked when tendering evidence. When we are tendering evidence, there are certain things we must do for us to be sure our evidence comes in. And then of course, documentary evidence. Documentary evidence, how do we tender it? What do we tender? Through whom do we tender it? And of course, we are going to look briefly at admissibility of computer-generated evidence. This is the general flow chart of civil procedure in Nigeria. We have disputes occurs, and of course there are different options. Dispute occurs, of course you can go to pastor, or you can go to imam, or you can go to ADR court and get it settled. in which case maybe we may not earn as much as we are supposed to earn. Or you can go to the other side and then start looking at the preliminary issues like application of the rules, what laws is applicable to the dispute, and of course the lawyer and the client. Who is a lawyer? The client gets a lawyer, and of course the client is there with the dispute, and of course you decide which court, which jurisdiction, where do I file this case. And then of course you have notice, you take notice of the notices and limitations. Is there a limitation on my dispute, on the dispute? Is there any limitation? And then of course the people who are the parties that are important. Who are the parties that are important? Is there any party I should join for me to get the objective of the matter? And then of course choice of process. How do I commence this suit? Is it by writ of someone? Is it by petition? All these are preliminary issues that must be dealt with before we go any further. And then of course we now move, if it is statement of claim, you finally decide. Of course you do your statement of claim, you file your petition, you file your originating summon. Of course you now take cognizance of service. Service, where do I serve? Do I need to serve outside jurisdiction? Or do I serve within jurisdiction? All those things are very important because you can get to a stage where it will be thrown out just because of the issue of service. And of course, once you serve, it comes in with statement of defense. And then of course, once the ADR process fails, the next thing we see is that we go back to filing statement of defense, and then we have discovery, pre-trial conference, we have pre-trial, and of course we now go to trial. You may look at it a little bit and think that okay, this is Lagos. Of course I'm coming from Lagos, so most of the things I'll be talking about to be about Lagos. And of course after the pre-trial conference you have the ADR directive. They can be directed to go to the multi-door courthouse, and then the determination of issues. You file your issues for determination, and then the case goes on from there to trial. And either the court grants the claim or rejects the claim, and then we go to appeal, and then if we get judgment, of course enforcement comes in. Prior to preparation templates, in preparing for trial, the following must be considered. Witnesses. Who are my witnesses? Who? You may have a lot of people that witness, but who are my best witnesses? Who are the ones that will ensure I get judgment in this case? You need to be sure you're calling the right witnesses. And then that now takes us back to what we learned during Demi's paper, that you have to make up your mind, what is the objective of calling the what do I want to elicit from this witness? Is it important to my case? And of course the originating process, we've talked about that before. And then taking evidence before trial. This is very important. Taking evidence before trial. You must call it any other name you want to call it, schooling the witness or anything. It is very important. You cannot take your witness to court on the day of trial if you have not done pre-trial with your witness. You must sit down together, go over all the documents you are going to be tendering, and be sure your witness understands what is going on. I've had cases during pre-trial, we found out that there were issues that the client did not make known to us, which the staff in the organization knows about. But the client, when he was entrusting us, did not give us that information. But during pre-trial, we found out that indeed that we need that information, because the staff was part of the transaction, so knows it as what do I need to do about that. And then of course general consideration, oral evidence, documentary evidence. And my evidence, documentary evidence, are they public or private documents? Do I have CTCs where they are necessary? Because it's during pre-trial you notice all those things. If you don't do pre-trial and bring out all your documents, okay, that day, okay, where are the originals? Oh, I don't have original of this one. I need to get this one. I need to get this other one. And it is always advised that you do it at least a week before the time, and still do another 1-2 days to the time, so that your witness is very comfortable with you. And then of course you look at reports or records you need, pre-trial materials, orders, and then of course the laws you're going to court with. And then the role, let us now understand the role a witness plays in achieving success. Generally, a witness is key in presenting evidence in court. All evidence to be relied on, to be presented in court, and all evidence to be relied on at the trial is to be tendered through a witness. Witnesses include, in general, all persons from whose lips testimony is extracted to be used in any judicial proceeding. Of course, in Nigeria, most of our witness, as a plaintiff, your witness is going to be giving deposing to deposition on oath, which is what you are going to use. But under cross-examination, it can be asked any question based on what he has deposed to. And of course, testimony of witnesses before a court are usually under an oath, and we know that already. And then witnesses to testify are to give evidence of relevant facts in issue. So it still boils down to what do I want? What fact is coming from this witness that is relevant to my case? A competent witness is a person considered in law as fit and proper to testify. All persons are competent to testify, subject to certain exceptions which we find in section 175 of the Evidence Act. Subject, however, to the limitation imposed by section 175 of the Evidence Act. Not all competent witnesses are compellable. In criminal cases, an accused person is not a competent witness for the prosecution. He is, however, a competent witness for the defense when he elects to be a witness. That's section 180 of the Evidence Act. The accused person in criminal trial is not a compellable witness for the defense, as he reserves the right. He reserves the right. Even as a defense, he can say, I don't want to give evidence, and he reserves that right to himself. That is entrenched in our Constitution. Generally, the spouse of an accused are not compellable. You cannot compel them to give evidence. And then proof of facts and rule against hearsay. Of course, everything that the witness is going to say will be what he saw. Of course, we know that section 37 and 38 of the Evidence Act is against hearsay evidence. It's not admissible in law. And then corroboration in criminal trial. The testimony of the following persons as witnesses require corroboration: the testimony of an accomplice, the unsworn testimony of children. The unsworn testimony of children require corroboration, and the testimony of a tainted witness. Examination in chief. Examination in chief. Examination in chief is as a plaintiff counsel. Examination in chief is your first weapon that you tender. Examination in chief is the first questioning of a witness in trial. That is your first bringing forth of your witness to give evidence. And like I said before, you usually have the position of the witness on oath, which is admitted in evidence. And of course, the object of examination in chief is to elicit from the witness material facts. Material facts. You need to note that material facts. Even if, like this person said, you don't want a witness to keep on giving you witness about testimony about their life journey. That's not what you need. What do I need from this witness? And you try to make sure the witness gives you exactly what you need when he or she enters the box. In litigation, when witnesses are called in favor of a party, it is expected that the examination in chief is a procedure which is more likely to prove the facts, because that is where you prove the facts of your case. Examination in chief. And then the advocate seeks to establish to prove the facts which the advocate seeks to establish than his cross-examination. If you're waiting for cross-examination to bring out your facts, the other party's witness may be a very thorough person and he will not give you what you want. So anything you don't bring out during when you are in control, which is your examination in chief, it's difficult to actually bring it out because there is no certainty on the other party's witness. You may be thinking, okay, the party will call this witness and I'm going to ask this question. What if the other party elects not to call that witness? That means there is a problem. So you use the weapon you have. The modern method of conducting examination in chief in civil cases is by front loading. So it means that at the beginning I must take absolute care to prepare my case, because we are front loading. Everything goes in before time, before you even get to that time of trial. So at that front loading time, I must have done my homework, brought out all the witnesses and known what I want to extract from each witness, and have a roadmap for my case. And for witnesses to be examined in chief, therefore, the system of front loading makes it a lot easier. It makes it actually easier. You know, at times you think it's a lot of work. Why now? Why do I have to do that work at the beginning? I found out that when you do the work at the beginning, the other way becomes very easy. I know in my office we have something called case management. You know, at the beginning you'll be thinking, why do they make me go through this case management? Why do they make me do a case intake memo that brings out all the arguments I want to do in a case at the beginning of a case when the client is just briefing me? But I have found out that when you do that, the rest of the case becomes easy. Even means that when I'm not around, anybody that picks up the file knows from the file what is to be expected, what our objections are, what our strategies are. So when you do your work at the beginning and front-load everything, you find out that during the process of trial, it becomes a lot easy. In criminal litigation, front-loading of witness deposition does not arise at all. The witness is led to orally give evidence. We are aware of that. In criminal litigation, we are not allowed, we are not expected to do witness deposition. It is important to know that before a witness goes to court to give evidence, he must go through some rehearsal. You must go through some rehearsal. This is very, very important. Don't just say meet me in court or on Monday morning, and then you meet by 8 and you try to do something before 9. It never works. All documents to be relied upon by a party must be tendered through his witness during examination in chief. Remember, all your documents that are relevant to your case must be tendered during examination in chief. During the examination, in civil cases, those documents must be referred to in the witness statement on oath already front-loaded. There are many cases where we have gone to court and somebody is trying to tender a document. I'll just say, my lord, I'm not seeing it in the witness statement on oath. It's not anywhere inside the witness statement on oath. Maybe there are documents that come up later. They will say, I'm going to kill her with these documents. And the defense counsel will come to me and be showing me documents. I will say, okay, this is nice. I want to know, I'll check my witness statement on oath. Is it there? Did they refer to it at all? If they did not, I will keep quiet. Immediately he rises up to tender it, I will say, my lord, it's not in the witness statement on oath. So we make sure that when we are preparing that we are prepared. That the witness statement on oath, every document that we want to rely on is referred to in our witness statement on oath, even if it is in passing, so that when you are talking about it, you will now say it is there already. Of course, the exception to the above is when we do subpoena and CTC of a public document. Central to analysis of documentary evidence are the issues of admissibility, custody, and relevancy of such documents. The issue of admissibility and where is it coming from, the proper custody, and is it relevant? They are very, very important. Admissibility of documentary evidence is determined by affirmative answer to the following. So these are the following questions you will ask yourself in civil trial. Is the document pleaded? Was it pleaded at all? Is it relevant to the inquiry? Is it relevant to my case before this court? And is it admissible in law? At times the document may be relevant, but it doesn't favor you. You won't want to bring it out. You will keep it, no matter how altruistic your motives may be. If a document is not in your interest in planning for your case, you will leave it out for the other party to bring it if they have it. Types of documents. Of course, under the Evidence Act, we have two types of documents, public and private documents under Section 102 and 103 of the Act. The content of document may be proved either by primary or secondary evidence, as is provided under Section 86 and 87. In proof of a public document, it is only the original that is admissible. The only secondary evidence which is admissible for public document is a certified true copy. Who is the appropriate person to tender public document? Of course, a lawyer can tender the CTC of a public document from the bar. A lawyer can, through his witness, tender public documents. Of course, you can also tender a witness. A lawyer's witness need not be a public officer. You must not be the public officer. Maybe you're tendering the document from CAC, you can bring a CAC staff. You mustn't be a CAC staff. And of course, proof of private documents. CAC means a Corporate Affairs Commission. Sorry, I'm using acronyms. Proof of private documents. Of course, in proof of a private document, only the original is admissible. Secondary evidence is only admissible in circumstance defined in Section 89, where you have laid the proper foundation. The test of admissibility is relevance. Once a document is relevant, it is admissible. An expert should either have qualification professionally in the relevant field he is going to testify in. If you're going to be using an expert witness, the expert must have the right qualification. Or even if he doesn't have a certificate, he must prove that he has been doing that work for a long time. If the person is not an engineer but has been building house for the past 20 years and has shown you documents of houses he has built, shown you pictures and everything, of course the person has acquired some knowledge within the town. We can see that in the case of Unipetrol, PLC and Advocacy. Expert evidence should face the fire of cross-examination. we should not let the expert go free, because indeed their evidence is usually very tight. So you should not say an expert after giving examination in chief, you will say, because he's an expert, I don't want to go there. Try and find a way to poke a hole in his qualification or even in his testimony. Expert reports must not be hearsay. It cannot be prepared by one person and another person comes to give it. It must be the person that prepared the expert report that would give the evidence. Of course, when we are having land matters, we should note it. Any land document, that any legal mortgage or C of O that is not registered cannot be used in evidence. The Land Use Act makes that clear. You must have the consent of the governor, it must have been stamped, and then it must have been registered fully at the land registry for it to be admissible. An unstamped mortgage document cannot be admitted in evidence. An advocate may need to tender computer-generated evidence. We are now going to computer-generated evidence. By Section 84, we know that a computer-generated evidence can be tendered, but there are certain conditions which must be fulfilled before a computer-generated evidence it becomes admissible. And if you don't comply with this computer-generated evidence, you will not be able to bring in your document. I had a very sad case one time, and I was tendering a document, right? And it was a computer-generated evidence. And the document was sent to us, right? And because it was sent to us as a client, the IT person in my firm was the person that deposed to the certificate. The certificate saying that it was brought out in the normal business of the firm and all that. And of course, when we got to court, the court rejected it. That it is the IT of my client, is the IT department of my client that should have printed out the document and given the certificate, not us, right? Even though we're on appeal, but the objection he raised was that it was hearsay, that our IT person is giving a hearsay evidence because it was not him that made the document. It was the other company, our client, that made the document. We're on appeal because we are still, I really don't agree with that, but we should prepare for such issues. Of course, notice to produce, when we know when to give notice to produce, when the other party, the original is in the possession of the other party and we need it, we give a notice to produce, discovery, subpoena, when we need the document that is another person's. And then visits to locus in co. Of course, Section 127 of Evidence Act, a judge may visit the place, person or thing where the court forms the opinion that same is material for the proper determination of the case. So where a particular venue or person or something that cannot be moved to the court, wherever the thing is, the court can form its opinion that I must see that that is material to the case. The court can decide to visit that. And then we go to cross-examination. Cross-examination, like I told you, is going to be taken by Mr. Fola Atowori, so I will just go over it. Of course, cross-examination is questioning of a witness at trial or preparing or hearing by the party opposed to the person who called the witness. It is done by the opposing party, not by the person who calls the witness. The purpose of cross-examination is to test the veracity of the witness, to shake the witness. To shake the witness. Oh, the person is saying, oh, I have been a very wonderful man, I have been so honest, but you know the person is using a fake WAEC result. You can bring that out, even though it may not seem relevant to the case, but you can bring that out to show that if you're using a fake WAEC result, you cannot be as honest as you say you are. So you just do those things to shake up the witness a little bit so that they can pave way for what you want to do. And one way to manage the rule of cross-examination of a witness is to play a role during pre-trial preparation. You need to prepare your witness for cross-examination. Like I said, you don't just throw the questions that are good, your own questions to the witness. You have to make sure that you also prepare the witness for the questions that will come from the opposing party, because that person will not be kind. That person will not be kind at all. I had a witness one time. It was my senior colleague that was doing the cross-examination, and it was really very interesting. The man was a chief, right? And he has this thing that you must call him chief. And my colleague, of course, always forgets to call him chief and calls him his name. He rattled the man so much that at the point he started shouting in court, and once he became rattled, of course he couldn't do what he wanted to do anymore. His witness and everything, you just see all his case become scattered, and the court had to tell me, you must answer the question. I don't have to call you chief, that is in your name, you know. And that was the way to rattle that person. So we need to prepare if you notice that your witness has an ego issue, prepare him that indeed in court, the other party may not call you chief. He may not call you whatever he prefers to be called. So all those things make the witness to be prepared ahead of time for any eventuality. Cases which would otherwise have been simple may become complex if the witness is not properly prepared for cross-examination. You may think that I have a very good case. I have a very good case. My case is foolproof, you know. Anybody can see that, you know, my claim should be granted. If your witness is not prepared for cross-examination, a lot can go wrong. The witness must be familiar with the issues in controversy. He must be familiar with it. You cannot take somebody that doesn't know the full transaction. Even if they don't know the full transaction, make sure he goes to the person that knows it to familiarize himself with the full transaction. I talk in the case of a company. Of course, a witness, anybody from the company can come and give evidence. In case they didn't send the person, maybe the person that handled the transaction had left the company and they sent somebody else. The person they sent, you must be sure the person knows the controversy very well. I have seen witnesses that said, I don't know about that one, or when that one happened, I was not in the employment of the company, and it wasn't very funny at all for the counsel. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing relative to matters in question in the suit. This means one can tender such documents in evidence previously made by the witness during cross-examination. If there are other documents that the witness has made somewhere, I can bring it during cross-examination and tender it through the witness. It is tactfully better to refrain from cross-examination than to do it badly. It is there was a day I was in court, and I think it was the Oba of Lagos who was a consummate lawyer. He was the witness, he was in the witness box, and the way he treated the counsel on the other side, he was like he was the one doing the cross-examination, you know. So in such cases, if you know that you have such witnesses, you're coming against such person, you should prepare for that eventuality. And if you know really that you don't have anything much to gain from that particular witness, that the witness is only going to make the case of the opposing party stronger, then you I might as well refrain from cross-examination. There is no rule that says you must cross-examine, except whether it is very germane and important to your case. And then, of course, there is another issue. There are certain issues that may be better to bring out in your final written address. There are certain questions you should not ask. You can imagine if I'm the plaintiff and I ask certain questions, and then the defendant wants to go and amend their process. Of course, you can amend at any time before judgment. If I can ask questions that will not make them to go and do certain things which will make their case stronger, then I should refrain from asking such questions. So you ask yourself, what is the purpose of my cross-examination? The questions, what am I going to elicit? Is it going to make their case stronger? Remember, they have an opportunity to go and amend their process. And if you let them see that loophole, right, they can go and amend their process and you don't have anything to say. But at times, if it's something that you can address in the final written address, then you leave it. When you get to your final written address, you deal with it very well. The role of witness. To achieve success, relevant documents which are required to prove a party's case need to be tendered through a witness, having laid proper foundation. By pleading such documents in the statement of claim or statement of defense, depending on what part one finds himself, and also stating such documents in the written witness statement on oath. Never forget that any document you're going to rely on must be written. You must, even if you just say, I rely on this document, and don't say anything about it or how it relates to the case, is even better for you than you didn't mention it at all. You must mention it in your witness statement on oath in civil trial. Apart from the witnesses, there are other procedures and processes to be complied with to ensure that credible evidence is available upon which judgment can be obtained. There are other processes, like we looked at subpoena and notice to produce. All these are things we can do. That is why I said in the beginning that preparation is very, very important. At the beginning, you prepare, you know the one you are going to subpoena. If it's a public officer, there's a document you need from CBN, there's a document you need from Corporate Affairs Commission. You know, you map out you have your roadmap for the case, so that when you come to that, you know, okay, this is how I'm going to deal with this when I get to it. In conclusion, as discussed earlier, the extant regime of front-loading in our civil procedure rules in Nigeria makes the need to have a witness in court during trial to be much more than something desirable but a necessity. It therefore follows that the selection of witness is a matter for the tactical decision of the advocate. You must tactfully decide, who are my witnesses? Who are the ones I am going to use? It is not all of them that you must use. A lot of people saw the event, a lot of people saw when the murder took place, a lot of people that were there, but you must choose the ones that you know will be able to stand in court, and even under cross-examination that they will also stand. Although criminal trials do not adopt front-loading procedure, a good advocate must put his house in order ahead of trial to ensure victory. After all, you have your proof of evidence with you. So for you to actually succeed and ensure that you do well at the trial, you should make sure that you put your house in order and make sure that all the things you need, all the witnesses you need for each point and each stage of the trial is well and good. In the end, examination of witnesses with the key aim of presenting relevant evidence is a mix of art and skill. Is a mix of art and skill. So you cannot say, I was born with it. You have to learn how to do it and do it well. Some of it can be acquired by experience and study, but a great deal of the advocate's success in the examination of witnesses is an art endowed naturally in a gifted advocate. So you have seen that it's not just about experience. We also get for some of it from our genes. Okay, I know how to do it. I know how to intimidate people. I know how to do this. You know, but once you know how to do all those things, it is also easier for you to fall into a pitfall. Oh, because I am very skilled in it. You now make up your mind, oh, I can wake up from the bed and just go and shake my body as usual and things will happen. Your case will become the case of the proverbial of Samson in the Bible that thought he could go and shake himself as usual, and the bonds will fall off him, and it did not fall off. You know, so once we master this art of presenting our evidence very well, we can do very well. It's now time for questions, and I know my people are ready to answer the question. Do we have any question or comments? Any comments? Thank you. Thank you. Thank you very much. Any question? Thank you for not asking any question. So with that, we've come to the end of today's program. We are starting to... You're raising your hand for question. What is happening? No question? Please, if you have a question, you can ask. Do you have a question? Okay, he hasn't made up his mind whether he has a question or not. But, okay. Please. Microphone.
I'm an advocate. Recently, I don't know all this. Why should a lawyer put all these efforts that we are talking about? You put in all these efforts, and then in the end you get judgment, as you are saying, judgment, then enforcement from the organogram that appeared, and you can't enforce judgment. For example, I have monetary judgment against ABU, or monetary judgment against Corporate Affairs Commission or Nigerian Army to pay 50 million naira damages or whatever. I have all my witnesses, everything is okay, and then we get judgment, I can't enforce because I have to seek the consent of the Attorney General, who is an executive member of the executive. I will write to his Attorney General. Attorney General, I have obtained judgment against the Nigerian Army for 50 million naira, or Nigerian police for unlawfully detaining me for 1 year without trial. Please, I want your approval for the police to pay me the 50 million, and Attorney General just keeps quiet. So what is the use of litigation? In the final analysis, shouldn't we just find a way of taking the law into our hands? No, it's a serious question. Since if I get judgment, I go through all these things, suffer the witness, everything, then I get judgment. After I get judgment, I must apply to Attorney General to ask for his approval. If he doesn't give me approval, that money I can't get it for the next 1 million years. So what is the use of the litigation?
You know, I believe that is an administrative issue which we are all faced with. You want to say something, please? It's an administrative issue which we are all faced with, and which the system can cure itself of. And of course, when I know that once there is a law and there is a procedure in place, at times we also look at the mischief which the law tries to guard against, because it can be all over the place. People can go and get all manner of judgments from we know where we normally get those kind of judgments, and they will come and levy it on the federal government without. I'm not speaking for the government. I'm a private litigation person also, really. So, but the way I look at it is that there is also a mischief which the government is trying to cure by having that administrative rule in place. And when we look at it, and once those rules have come, there's always a downside and an upside in it. And if we find out that the downside is too much, it's for us to still go back to our legislature and do the right thing and get it solved. That is what you want to say. Okay. Something.
My own is observations, not the questions. I think it arose from the last questionnaire regarding the seeking consent of the Attorney General before judgment will be enforced. I don't believe it's applicable in all cases. There is a Supreme Court decisions of recent that except the money is being warehoused in the CBN. But when you have a party, like if CAC is a party, I've done garnishee against CAC before, and I didn't seek the consent of the Attorney General. We have cases, we have scenario where it is mandatory to seek the consent of Attorney General if the fund involved is being warehoused by the CBN. But in other cases, I don't think so. So it's just a clarification, not in all cases.
Single accounts. Now we have TSA. Now we have TSA right now. Exactly, this is with CBN. So it's still affected. Okay, please.
Please permit me to begin by thanking the presenters today, Jeremy, Scott, and yourself for the highly incisive and impactful deliveries. You know, so much value has been added to us today, and we cannot thank you enough. I think the issues, being raised now are issues outside of these papers for us to, do some serious thinking about and see how we can also advocate for reform and charting a way forward. In addition to that, this morning I see so many similarities, in the system, the U.S. system, and what we have in Nigeria. Yes, so many similarities, except for one thing, which is simply an issue relating to delay in administration of justice. In all of this, we have the front-loading system. You have the laws in place. You have trials here, criminal trials here that can last for 10 years, 5 years. You know, I'm not sure you have any such situation in the US, you know, and I really like to know how, you know, we can improve the system. We came up with this front-loading, you know, system regime, hoping that it will advance, you know, our administration of justice in Nigeria. But I think practically we're still at the same spot, you know. So can we learn from the system in the US? You know, how come you can have criminal trial just 1 month, it's done, you know, and over here we're still saddled with 4, 5 years, 6 years, 10 years, and all of that. Just hoping we can learn something from your experience and see how we can do an advocacy here for reform. Thank you very much.
What I can say to that is that on the 1st of November 2017, we are going to be having a symposium, a one-day symposium on administration, on speeding up criminal trials in Nigeria. We are basically going to be extracting the new ACGO, and if you are here and you registered, I mean registered online, you have the website has registration portal. If you registered online, you will receive an invitation. It's strictly by invitation, and we're going to be extracting. It's going to be, we have the judiciary, everybody's going to be there. We're going to be extracting the ACGO, and it's something I think you should be a part of, so that we look at our administration of criminal justice and look at where we are taking it forward and what we can do to ensure that even in all the states where it is being adopted, we do things and we do it right. Thank you. Yes, and we have Mr. Luke Fadden from CWAG. He has been at the Hague. He was a prosecutor at the Hague, and he has been a consummate prosecutor. He's going to come and be telling us about this, apart from our Nigerian people that we also have on ground. It's going to be a very robust day. It's going to be wonderful. So I think it's something you should look forward to. Symposium. No, it's not free. It's free. It's free, but it's strictly by invitation. Please give me a microphone.
Please, I really appreciate your presentation here. It's very wonderfully done. I'm sure you actually, Equity Team has done that which ought to be done. You did very much. The sound wouldn't have done better.
Thank you, sir.
So I really desire that we have a plenary session over this very important paper. It is germane to our practice. You know, the effective handling of evidence is very important, and I'm sure a lot of us will benefit. You see, I am sure it's actually out of this program, but maybe a gang plan can be made for us to have an interactive session, or maybe a plenary session over this paper, so that can be group discussions and you know, something, the communique can be reached.
Well, that is well noted, and in support of what you just said, I know Chief Idigbe, when he was talking about this, he said there was a, you know, the evidence, you know, when the police was trying to show, see what the person did, you know, the police brought out the bullets from his drawer. You know, he just put the bullets that was collected at the scene, he just brought it out and put it on the table with his bare hands, showing that this was bullets. So how do you, that has rubbished that evidence for the, and that case did not go anywhere. You know, this is what happens to our law enforcement agencies. We actually invited them, but they are not here. But we take back what you have said and we'll look into that. It is very, very important, and we ensure that our law enforcement agencies are well represented at that event. There's somebody raising their hand.
Yes, this has presented me with an opportunity to relate a case, a scenario that happened in a case I'm handling. There was this issue of a document, a photocopy of a private document that was tendered through a witness. It was admitted in evidence, and during cross-examination, it was discovered that that particular document was not properly executed. The parties that were supposed to execute the document did not sign, and their witnesses did not sign. this document was before the court. Then later, an original copy of that document was also brought before the court. They sought to tender the document, and it was objected to. But to my surprise, the particular judge admitted the document, and without inviting the parties to address the court on anything, the judge substituted that document with the previously admitted photocopy of the. And what happened is this particular new document now, the original, there were alterations, signatures were appended on the document, that is the places that were previously not executed, that is the signatures were appended, and even a passport photograph of one of the parties was attached to the document. I don't know the position of the law in respect of this. Please, can I be guided in respect of this?
Thank you, the resource persons. Thank you, the presenter, for a very nice presentation. I am Ngozi Agubalo, Mrs. of the MBA Abuja. My question, or rather contribution, will go in the area as your presentation went. It means an ideal situation of where investigation has been achieved in case of criminal prosecution, and now you are in court, the ideal procedure to go with. But in this country, we have a lot of high-profile cases which could not get to the court because of investigation to get evidence to prosecute the cases. And I think we should consider that area, because as a former commentator or speaker said, that we have to learn a lot from USA in their methods, even though we have some similarities. I want to point out particular issue, for example, concerning, will I call it expert witness or forensic evidence in investigation. For example, in context of Nigeria, Dana Air crash, we had it in this country, but we have to go outside the shores of this country to get DNA test for us to establish who the victims were, are for people to collect their victims' remains. The issue there is that, from my own findings, that we have a long way to go in the investigation, and it has been holding down high-profile cases, criminal cases. We go to that direction. If we go to US, they have gone far in DNA testing. But Innocent Project, using DNA, at times giving percentages of the DNA of what happened. At the end of the day, the credibility of certain results are impeached. That is, it means research. It means going forward. Certain things that were established before and their convictions were secured. But at the end of the day, he found that it is not right. Because the evidence, as it were, they thought it proved the circumstances beyond reasonable doubts. But further, as they move further, they found out that it wasn't proved beyond reasonable doubt.
Because of investigation?
Yes, from investigation. So that's why research and investigation is very important.
It is.
So,
it is.
Innocence Project, at the same time, as he's doing it, FBI can come up with certain results or PCAST. That's what they call PCAST in US. But there will be conflict as such as to a certain FBI can say this is this, or PCAST can, and PCAST can say it is not so. So now they are going on a higher ground. So I want that even when we want to reform, before we can go for reform, we will start somewhere. But we have not started somewhere.
you know what you just said now. What you just said now is very important. I remember I just came back from a summit for attorney generals in Nigeria, and I know one of the things that they discussed there is the issue of investigation that have been botched by our police and our law enforcement agencies. Is making the work of the prosecutors very difficult. And I remember at the workshop we had in Calabar, one of the issues that was raised by Justice Eno Ita of the High Court of Cross River State, he said that, because by the time we looked at the case study and how the police handled it in America, how in fact they took months to study the accused person, he was a suspect at the time, but they spent a lot of money monitoring him, getting evidence before they even arrested him at all. So that really made the work of the prosecutor very easy, and they were able to get a conviction. So we noted that indeed in all these things we are doing, we have to carry our law enforcement agencies along and make sure that they have the right knowledge, because if they don't have it, there is nowhere they can get it from. And then coming to your statement about documentary evidence, I can tell you offhand that the way our public officers handle our documents are usually very wrong. I have a case on my hand now, and it's going to, I don't know how long that case is going to go, but it was the handling by the public officers that caused that case. The case shouldn't be there in the first place. What is the case about? They filed a document in the probate, but because of the way they filed it, just like maybe when you file a bundle of documents, they usually remove the pins, right? In the process of removing the pin to tag the document, they took an appendix and put it somewhere else, and that appendix is very important. It's just like me I'm filling a probate form, and I'm saying at the back of the form that the deceased person doesn't have any family, right? The appendix has the list of all the members, deceased and alive, but because of the way they filed it, they removed it. It was no longer an appendix, and that is what is causing a big case in court. So the way our public officers handle documents are also administrative issues, which I think we need to handle as we modify and try to bring change to our system. We are all involved in it. Lawyers are at the forefront of it. We must recognize that. There is no better time in our country, Nigeria, than now. Lawyers are empowered to do things. And if we all put our hands on deck, the change we want to see, we will see it. And with that, we'll come to the end of today. But before we end, I want us to recognize the chairman of the Unity Bar, chairman of the caretaker committee of the Unity Bar, Mrs. Princess F. Frank Chukwani. She wasn't here when we recognized her before. Please, can you stand up for recognition? Yes, she's the chairman of the Unity Bar. Thank you so much. When we called you earlier, you were not here. She's come back. She's a woman of her words. Thank you so much. So we have come to the end of today, and we are going to have lunch. And when we go, please let us remember to read up our case on Castro. It is very important. It is 27 pages, and if you don't read it overnight, there is no how we'll be able to make progress. Using the ones on the website. Okay. So if you have any questions, you can treat that later. Thank you very much. A round of applause to yourself. You have been wonderful. Please, let's go and have lunch.
Girl, let's put it inside.